Good evening, everyone, and thank you for joining. I'm Pauline Bumble, and I'm an Associate Professor of Law at the Australian National University and leader of the ANU Private Law Research Group, which is hosting this event tonight. I would like to begin by acknowledging and celebrating the first Australians on whose traditional lands we gather. For those of us in Canberra, that's the Ngunnawal and Ngambri people. I pay my respect to the elders past and present. I also extend this respect to all Aboriginal and Torres Strait Islander peoples in attendance today. Before introducing our speaker, Professor Lindsay Farmer, I would like to note that we are recording this seminar and that the recording will be made available publicly after the event. After Professor Farmer has delivered the seminar, there will be some time for questions, and we ask that you raise your hand if you have a question, or alternatively, put your question in the Zoom chat forum. I would now like to introduce tonight's speaker. Professor Lindsay Farmer is a Professor of Law at the University of Glasgow. He has published widely in the areas of criminal law and legal theory. His most recent book is Making the Modern Criminal Law, Criminalisation and Civil Order, which was published by Oxford University Press in 2016. He is currently working on a book called Criminalising Market Misconduct, to be published by Oxford University Press in 2024. Tonight, the topic of Professor Farmer's presentation is Private Vices and Public Virtues, Market Misconduct, and the Legitimacy of the Criminal Law. It gives me great pleasure to invite Professor Farmer to deliver this seminar.
Thank you very much, Pauline, for the invitation. It's really wonderful to have the opportunity to speak to the private law group at ANU. And it's also especially nice as a criminal lawyer to have this kind of opportunity, because often I think we have disciplinary silos, and the criminal lawyers are not engaging with the private lawyers or vice versa. So it's especially nice to have that opportunity, although a little bit intimidating for me because of my lack of knowledge of private law. But I will rely on rely on you to keep me right. There are important overlaps, though, in this kind of area, in thinking about the relationship between public and private. And that's really what I want to focus on in tonight's seminar. As Pauline also mentioned, I wanted to say that this is part of a larger project. I'm writing a book called Criminalising Market Misconduct. And one of the things I want to do in that is to challenge criminal lawyers to think more systematically about the market, not only in the sense of market misconduct, what kind of misconduct should be criminalized, or what the role of the criminal law should be in relation to markets, but also to think about the place of the market in social order and how that works for thinking about the social institutions that criminal law is governing. And I can say a little bit more about that later on. But we'll begin with private vices and public virtues. And this, of course, refers to a famous quotation from Adam Smith. And as a member of staff at the University of Glasgow, of course, we like to celebrate Adam Smith as one of our distinguished alumni, former professors here at the university. But there's also a kind of misunderstanding of Smith. I mean, it's easy to characterize Smith as a kind of laissez-faire free marketer. And of course, there's a increasing recognition that Smith's thought is more nuanced than it's often presented by some of the people. Some people come promoting ideas about the free market. But we've just focused the moment on this quotation. He famously said, "It's not from the benevolence of the butcher, the brewer, or the baker that we expect our dinner, but from their regard to their own interest. We address ourselves to their humanity, not to their humanity, but to their self-love, and never talk to them of our necessities, but of their advantages." And I take this as a starting point because in some ways it represents a kind of modern attitude towards the market. Although there were other thinkers at the same time as Smith who were making the same kinds of arguments, Smith's position is sort of emblematic of a major shift that occurred in the late 18th century. The idea that the pursuit of private or self-interest could produce public goods. Previously, the view had perhaps been that pursuit of private vices, of private self-interest, was corrupting, and that the markets needed to be regulated. Private vices would drive out public good. Whereas for Smith, he's making the argument that private vices could lead to a public good, and this establishes a new kind of relationship between private and public, and between market and state. The market did not need regulating in the same way because the pursuit of private interest in the market would produce the public good. He was arguing that the market could become self-governing, the ideas of a kind of market discipline that could operate in this space. And that corresponded also to a kind of shift in the way that markets were thought about socially, in that many of the traditional regulations that have been around just price and the kind of restriction of competition and things like that were gradually stripped away over the early part of the 19th century, leading to the kind of Victorian era of laissez-faire. But there have also always been critics. The market has been seen as corrupting, with private vices driving out public good. Famously for Marx was the critique of commodification, which is a version of this this argument about the relationship between private and public. And even for contemporary philosophers such as Michael Walzer or Michael Sandel, they point to the destructive effect of market logics and the need to constrain the market, that certain things shouldn't be for sale, that there are certain areas of social life which should not be subjected to a market logic. So what we have is always something of a tension between the private and public, between the idea of the market as self-regulating or the idea of competition producing public good. And this raises a number of larger questions. Do we think of markets as private or as public institutions? And how should they be regulated? Is market misconduct a matter for private law or for public law? Or perhaps to say, from my point of view, for criminal law? Are private vices private, or should they be regarded as public wrongs and criminalized? Now, what I want to do in the talk tonight is not to think about these in sort of abstract terms, but to explore some contemporary developments in the criminal law and the way that the market is conceptualizing criminal law, and then to use that to see what that can tell us about the relationship between private and public and the way that the market is conceived. So what I'm going to do is I'm going to look at three examples of changing conceptions of market misconduct. And I take these as characteristic. I could use other examples as well, as many other examples. These are three examples that I think illustrate well the kind of shift that I think is going on. And the three examples I'm going to look at are trafficking, insider dealing, and market abuse. And I'm afraid my examples are all based on UK law, but I understand there are equivalent provisions in Australian law. So what I'm going to do is I want to look at how the offences are defined, and then how the market is conceptualized in these definitions, and then to explore the rationales that lie behind these developments. So first of all, then, we have the trafficking, and for England and Wales, this is contained in the Modern Slavery Act, Section 2. And it doesn't show up terribly well on the slide. I put in bold certain aspects of this. So the offence, it's based on the Palermo Protocol from 2000, and the trafficking, there's three elements to, or seen as three elements to trafficking from the Palermo Protocol. The idea that there should be conduct, that there should be a certain purpose and a kind of means. So the conduct is the arranging that we have up here, arranging or facilitating the travel of another person for the purpose of exploitation. And there's two then interesting features of the offence. So one is the definition of exploitation. The person is subjected to force, threats, deception designed to induce him or her to provide services and so on. And also that it's irrelevant whether or not the victim consents to the travel. So, and I'll say a little bit more about that later on. But I want to draw attention to then three features of this. The first is that the offence, the way the offence is defined here, is inchoate. So it doesn't require an actual outcome. It's arranging or facilitating the travel for the purpose of the exploitation. So it's interesting from that point of view, in that it kind of, the way that liability is framed, it's earlier in time, it's an inchoate offence. It's also relational, in the sense it's about the relationship between the arranger, the facilitator, and the victim, and captured in the idea of exploitation. So what we're asking, what kind of relationship is this? Is it for the purpose of exploitation? But then exploitation is defined in a very vague or open-ended way here. It's in relation to a norm. It's illegitimate exploitation, but actually the statute doesn't say very much about what illegitimate exploitation is. So it's actually being defined in relation to norms or expectations of certain kinds of normal employment contract that exist outside the law, so that something is exploitation if it's not that. But I think that's implicit in the definition, and this is never really pulled out. Let's move on then to my second example, which is insider dealing. And here in the UK, we're looking at the Criminal Justice Act 1993, section 52. So it's defined as an individual who has information as an insider if they deal in securities in relation to the information, and if they do so on a regulated market. So what's important about the definition here is, once again, it's inchoate. So it doesn't require an actual result. It's having information and dealing. So it doesn't require that you profit from that. It doesn't require that somebody else profits from that. It just requires that you have the information and you deal. It also is, in a certain sense, relational. It depends on a position. So you are an insider. Of course, there's a certain amount of case law then about the meaning of what an insider is, and dealing on a regulated market. Why is it framed in these terms? It's about protecting the operation of the regulated market in certain ways. I think there's an increasing focus on the inchoate offence, because it's very difficult, as trading becomes automated, to disaggregate and identify individual transactions. So it's not possible to say, well, this is the an advantage was gained from a particular transaction. And it's about protecting certain kinds of information in the market, so the market price formation mechanism can operate properly. And then we see the third example here. This is the market abuse offence, which is based on the EU market abuse regulation, and is contained in the UK in the Financial Services Act 2012, sections 89 to 91. And there's three separate offences here. They're all related. It's making false or misleading statements, creating a false or misleading impression, or making misleading statements or creating false impressions in relation to benchmarks. That's to say things like the LIBOR rate and so on, as kind of famously happened during the 2008 crisis. And we can see once again that these are inchoate offences. It's about making the statements, making false or misleading statements, or creating a false or misleading impression, and so on. It's not about actually a particular result. And once again, that it's defined against a kind of norm, which is not which is implicit rather than articulated. So what's a misleading statement? Well, that is not actually made clear in the legislation. There's a kind of, it's assumed, that there's a kind of knowledge, a background about what the normal conduct is, and therefore what would be false or misleading. False is perhaps clearer. There is a sort of standard, something is true or false in a certain sense. Misleading is very vague. And so the definition of misleading is harder to articulate. And once again, the concerns are with protecting price formation mechanisms of the market. So what's going on here? I'm not going to spend too much time on this slide. I've kind of covered much of that in what I've said so far. Pointing to changing forms of the criminal law here is specifically the idea that we have the tendency to create inchoate offences, to create relational offences, the conduct defined in relation to normal practice, and that is in some ways is different from the classic form of criminal law, which usually classically would require the causing of a harmful outcome with a particular kind of intention or mental state. So here, it's clear that there's something different going on in the movement to inchoate offences. And I think that in some ways is connected to changing features of markets, in particular financial markets, but not exclusively financial markets. And the aim or the desire to protect certain features of those markets. And I think one of the important shifts then here is that there's a shift from the idea that the criminal law should be protecting the interests of individuals in markets. So stopping an individual being defrauded, or an individual has their interest in their own property rights and so on. And you protect the interests of the individual in the market. And the shift is towards protecting the market itself. So the market is emerging as an object of protection in a particular sense. Specifically, this is, I think, what I want to argue, and this is what the sort of larger argument of the book I'm writing, is that the criminal law is, there are certain features of markets which are increasingly protected by criminal law, but that these are then backed by a kind of larger sense of, but again, implicit rather than actually articulated sense of how markets ought to operate. And what I'm interested in is in a sense in pulling out and thinking about the different features of markets, the architecture of markets, and how criminal law is used in relation to that, but also bringing out the larger sense of the how markets are understood to operate, and whether that's a good idea of how we think markets should do or should operate. And I'll explain that in just a moment. Now, let me just say something about the kind of market architecture. Now, the sort of classic idea that we find even in thinkers like Hayek is that markets rely on private law, in the sense that markets rely on an idea that there has to be security of contract and there has to be security of property. So the law is constitutive in some way of markets, but it's private law that's constitutive of markets, not criminal law that's constitutive of markets. However, markets have other features. So the kind of interesting recent work in sociology of markets by people like Neil Flickstein, I've put on the slide here, but also Jens Becker and so on. They talk about the architecture of markets, and they point to other wider features. So markets are about preventing exploitation. So it's about there's kind of The a properly working market, it obviously is allowing people to pursue their own private interests and so on, but that not to the extent of exploitation. So there are a number of regulations which prevent exploitative relationships. Likewise, there's arguments about protecting information flow. So we see that in relation, for example, to insider dealing, market abuse. We have the idea of trust, that you should be able to trust other people who you're engaging in market transactions with, and obviously some of that is done through mechanisms like contract, but there are also criminal law rules which would protect you against being defrauded by certain people. But also, it's also not just trust in other individuals, it's trust in the market as a whole, that you trust that the market is operating properly. And of course, there are a whole raft of regulations around the idea of competition, that the competition should be fair competition, so that we have cartel offences, that we have, again, in relation to things like market abuse, that the competitive mechanisms of the market are working properly. So what people like Flickstein are arguing is that the architecture or the design of markets is more than just the constitutive features of private law and contract and property, but requires the protection of these other features of markets: exploitation, information, trust, and competition, and that there are the regulation of markets through combination of private law and public law, criminal law, is designed to ensure that these features of markets are working properly. And to some extent, so just to tie it up with the first part of the talk, the point here is that when we talk about exploitation, information, trust, and competition, we can see that in the various offences that I was looking at, the trafficking, the insider dealing, the market abuse, that they're about preventing exploitation, about ensuring the free, proper flow of information, the proper operation of price mechanism, ensuring that competition works properly. So these new offences are addressed to protecting these specific features of markets. Behind all these, though, I think there's also a sense of, as I say, protecting the market itself. And this is often articulated through the concept of market integrity. So what is meant by market integrity? And I put some examples up here. I mean, once again, there's many more examples that it could use, and I just picked these out as kind of indicative for the areas that I'm looking at. So this first one from the Financial Conduct Authority, specifically in relation to market abuse. Market integrity is ensuring stability and resilience, access, effectiveness, and predictability, fairness and cleanliness, which I think is an interesting idea. I hadn't really thought about cleanliness in relation to markets, and the prevention of financial crime. The next one down from the World Federation of Exchanges report, market integrity is a cornerstone of fair and efficient markets, ensuring that participants enjoy equal access to markets, that price discovery and trading practices are fair, and that high standards of corporate governance are met. So it's bringing in an additional element there of corporate governance, which I think is interesting. And then a sort of somewhat broader sense from the bottom here. This is Kofi Annan's forward to the UN Convention Against Transnational Organized Crime. And I think he's invoking a kind of different sense of market integrity here. It says, arrayed against these constructive forces, however, in ever greater numbers and with stronger weapons, are the forces of what I call uncivil society. They are terrorists, criminals, drug dealers, traffickers in people, and others who undo the good works of civil society, take advantage of open borders, free markets, and technological advances. And I think specifically here, there's kind of invoking the idea of the civil market, if you like, that is working properly and that is somehow polluted by those who cross the borders, who traffic in and affect the operation of the civil market or the civil order. So that's market, and some examples of how the idea of market integrity is invoked here. But we can see from these examples that they invoke actually many different senses of market integrity. So, and again, we can find others in the literature. So the first one, we go back to the stability and resilience, access, effectiveness, and preventing financial crime, is, if you like, is about integrity of the price formation process. So integrity here is appealing to a kind of economist idea of how the operation might work. Specifically, you see it in things like the efficient capital market hypothesis, famously associated with Eugene Farmer. The idea that there is an integrity to that process, and that something that interferes with that integrity will prevent the price formation process from operating properly, and therefore will send the wrong signals to market participants. Now, that's a very narrow and abstract sense of what integrity is, based on sort of economic theory. We also saw, though, appeals to the integrity of benchmarks. So we have LIBOR and Euribor and their replacements. And appeals to integrity here are a different kind of appeal to integrity. It's that the benchmarks are used, but that they should be formed in a proper way, so they're a reliable or an accurate standard. And that's not actually relying on the market operation as such. It's appealing to a different kind of idea of integrity and the impact of integrity. It's also important to note that integrity might mean the personal integrity of particular traders, that the integrity of the market depends in some way on the personal integrity of the market participants. The idea of boundaries, so that you have to protect the boundaries of particular markets. So we have licit and illicit markets, the idea that's being appealed to by Kofi Annan, civil and uncivil markets, or free and unfree markets, and the way that markets can be contaminated in certain senses. And it's interesting, and that kind of, again, if we look back to the previous slide, was the cleanliness and things like that. There's a kind of there are ideas of contamination being appealed to here, which are, again, sort of not really. It's never really articulated what ideas like contamination might mean. We have financial trust in the market itself, appeals to the orderliness of the market, which again is kind of interesting. Orderliness is, what might that mean? It might mean, simply that the market. It might mean something similar to the idea of the integrity of the price formation process. It might mean something broader. And there's a kind of appeals of, also to the idea of fairness of the market in the integrity. But the fairness of the market is also a much broader idea. Fairness is not just about necessarily the internal operation of the market, but it can appeal to broader ideas, like the fairness of the market, the role of the market in society, and whether or not that's operating properly. And my concern here is that for something like market integrity, which becomes a kind of organizing principle here, is appealed to as a sort of concept that is to be protected, is not actually clear what people are appealing to, or legislation is appealing to, or the kind of the sort of policy documents are appealing to when they actually are invoking this idea of market integrity. Because they sort of throw in everything. You get, it is the cleanliness and the integrity, the the cleanliness and the stability, resilience, effectiveness, access, predictability. And I mean, nobody would disagree with any of these things, but at the same time, it means nothing. And so, my argument would be that, for purposes of criminal law, especially, if we're talking about the role of criminal law, whether or not that market misconduct should be criminalized in order to protect market integrity, there has to be a much clearer sense of the particular kind of market integrity that we're seeking to protect, and what that says about the role or the fairness of markets and their position in society. So let me finish then by saying something about this and in a sort of general sense about this and the changing role of the criminal law. So as I've tried to argue throughout, these new offences are protecting the market as an interest rather than the interests of individuals in markets. And I think this is an interesting and important development, and we need to kind of focus on this and recognise it. It also, in terms of the language I used at the beginning, the relationship between public and private, I think it marks a shift from seeing the market in some ways as private towards seeing the market or certain markets as public. There is a public interest in the operation of markets, and criminal law is being used to protect that public interest in the fair integrity of markets and the way that they operate. And this is an important shift. It's not, I think, being recognized by criminal lawyers adequately, or the significance of this kind of shift. And that part of what I'm trying to do is to draw attention to this and argue for its significance. So what we see then is criminal law is playing a role in regulating private markets, by contrast to classical conceptions of the self-regulating market. So we're moving away from the idea of market discipline as operating effectively to drive out private vice, towards the idea that in certain markets, criminal law has to play a constitutive role in the protection of certain features of markets and of the idea of market integrity more generally. What does this mean then? I think it reflects an emerging conception of the public market, perhaps, rather than the private market. And this perhaps is also where it's interesting to reflect on the relationship between public law and private law. And I'm not claiming that only criminal law or public law is regulating this new conception of private markets, because clearly there's a whole raft of different kinds of regulatory mechanisms extending from private law through more what might be more seen classically as kind of regulation, the regulated market, but through and into and including criminal law here. But importantly, then, what I'm arguing is that there's this shift is so important that it becomes increasingly important that we engage with and try and define the concept of market integrity, both as a means of addressing the legitimacy of the criminal law in terms of what it's doing in this area, and to address the question of the social legitimacy of markets and their role in our society. So going back to Smith then, is perhaps the case that there is a kind of a shift from the idea of, as we started with, the private vices being driven out by the market, to a recognition of the market as a kind of public virtue and playing a public role, and the need. And I think in some ways this is very much consistent with Smith's thought in this area, with the need to reflect more about the public role of law, including criminal law, in the regulation, constitution and regulation of markets. And so I'll finish there. Thank you.
Thank you, Lindsay, for such an interesting and informative presentation. We do have some time for questions. So if you do have a question, please raise your hand or pop your question in the chat forum. So I'll go first to Sonali.
Thanks, Pauline, and thank you very much, Lindsay, for a very interesting presentation. When you were talking about market abuse and false and misleading impressions, because I trade shares, I'm very interested in this aspect, and I was thinking actually of the continuous disclosure requirements upon companies, and I assume that UK companies as well have this positive duty to inform the market of price-sensitive information. And perhaps you are covering that in your research and your book, but well, I think that's a really good case study example, because it is something that companies should be considering every day about price-sensitive information to disclose to the market. And it is the case, often a couple of times a week, or at least a couple of times a month, companies are disclosing information. Some of it is marked as price sensitive, some not. And at least on our stock exchange, if there has been a sudden dramatic price change with a stock and there has not been any notice recently, and it looks inexplicable or bizarre, the ASX will send what's colloquially known as a please explain letter to the company, and that's, everyone can see that in the market, right? And then the company is given a deadline where they have to provide information as to, is there any price sensitive information that you know about? So look, that was my comment, and if you have any thoughts on that, I'd love to hear.
So, thank you. I mean, it's an interesting example. I mean, one of the things I think that is interesting about it is the shift in the way that markets are policed, in the sense that the way that what market regulators are looking for is unusual shifts in prices. So that the movement is away in terms of the policing from looking at individual transactions. So in some sense, the classic ideas of, say, insider dealing, so which are where we're talking about the kind of price sensitive information, something like that, would be about the kind of famous sort of case law in this area is of an individual who gets the advanced information and then tries to kind of exploit that information in some way, and you can track it to particular kind of things. This is where we see the way that criminal law is changing, because transactions are happening so quickly that the measure of whether or not something is going wrong or not is unusual price movements. And so again, there's the idea of there's a norm, and if something is unusual in relation to that norm, and then the enforcement in kind of criminal law terms is saying, please explain, is putting the burden on the supposed malefactor to explain what they're doing, and again, I mean that's a kind of shift, because it's not looking at the kind of there has been an offence committed in advance. It's shifting the burden of proof onto the person asking them to explain that. Now, of course, I assume in Australia it can give rise then to a criminal prosecution if it breaches insider dealing regulations. Yeah. So if your explanation is inadequate, but again, what's I mean, as an example, it reflects the fact that it's about market level conduct. It's not about so much about the individual. The concern is, well, that the market at a market level, this is not working properly, and we intervene when there's some evidence that something looks irregular. But there's some kind of sociological work on the kind of the way this kind of policing. There's actually a very, I forget the name of the book, but I could send it to you if you're interested, looking at market policing and the way that in fact it again is kind of, there's not necessarily a reflective idea of what the market should be doing and how markets should thinking hard about that. It's the most superficial kind of price movements and kind of responding to that, rather whereas there could be a more fundamental exploration of the way the market is supposed to operate. So I think I'm not being terribly clear in explaining that, but I think your example is the kind of example that I'm interested in, because I think it does reflect the kind of shift that I'm trying to describe.
Thank you.
Akshaya, we'll go to you.
Thank you, Pauline. Thank you, Lindsay. That was really interesting. I, coming from a corporate law perspective, and I know this is probably not a majority view even amongst corporate lawyers, but I see this sort of, when you criminalize certain market conduct, these actions are also civil wrongs. So at a certain point, it can also be a criminal wrong. So I see it more as a kind of signaling function that this misconduct is really bad, and we're signaling from the government or the lawmakers that this is very bad for the functioning of the efficient markets, and we want to drive out this conduct. So we're making it a criminal wrong. And I wonder, in the context of markets, I think of it as the people we're trying to regulate have huge reputational costs as well. And this is kind of different from normal criminal law. And I wonder if this impacts your more theoretical positions that you started with.
Thank you. So, I mean, I think it's an interesting question. I mean, I guess I think, I mean, in some ways, I think you're surely right in the sense that there is a signaling function, and I mean we see this clearly in the sense of that there's a lot more legislation in this area than is ever enforced, and one of the kind of ongoing complaints is that offences are legislated and to signal that it's wrong, but they are never actually enforced. Now, I mean, the question is, at some level, you say, well, what do we do with that? I mean, so is it the case that they were just never meant to be enforced, and it is purely signaling, and that then there are the idea is that it's then going to be addressed through other kinds of mechanisms, or I mean, as a criminal lawyer, if that kind of thing, signaling is going on in other areas of the criminal law, we would regard it as a problem. So if an offence is created where if the legislature creates an offence which there is no intention ever of enforcing, we would see that as a problem, and so I'm not sure why we would regard market offences or market misconduct offences as particularly different. Now, it may also be the case that one of the issues in this area is that, as is also sometimes argued, is that it's just extremely difficult to police and to prosecute certain kinds of market misconduct, so that the offences have been created, and the difficulty is that we create them, but we can't enforce them. And again, I mean, that may very well be right. I mean, and if you speak to people who work in, say, in Britain at the Financial Conduct Authority and so on, that's a continual complaint. But I think so. One of the things I'm interested in there is to ask, well, what might be the how might we think of, is it just bad criminal law? Do we need to change the way that the offences are defined? Do we need to change the way do we need to think about the way the particular markets are operating, and then try and design the offences better, or think about the way in other words, to make them enforceable, and so that to some way it seems to me is the kind of challenge. And one of the reasons I kind of came into this area in the first place was after the sort of 2008 financial crisis. I mean, there was clearly widespread fraud, misconduct going on in many different areas of financial markets, which led in various kind of ways to the crisis and the collapse. And there was a public demand for something to be done, and that punishment be used, or criminal law be used. But in fact, in Britain, no one has been prosecuted except for a few kind of low-level traders, and very much like the low-hanging fruit that's easy to prosecute. I think Iceland is perhaps the only country that successfully managed any kinds of prosecution. And again, it's just from a criminal law point of view, that's interesting to me. And that if there is legislation, if there are changes, I think it has to be more than just signalling. I think there has to be something else going on, and I'm interested in then trying to take this seriously. Let's try and think it through and think. I mean, maybe maybe the offences are too broad, and maybe they're the wrong kinds of offences. Then we have to think, well, what would a more specific target offence look like? What would an enforceable offence look like? So that I don't think we should be using the criminal law in a kind of wholesale, widespread way. But equally, that if there is criminal law and it's seen as a kind of backstop in some ways in this area, then it ought to be enforceable. And so that, I mean, I guess that would be my answer. And I don't know what your response would be.
That makes sense. Thank you. And I think if you use it in such a widespread way, maybe the signaling effect is also diluted, because the more and more you criminalize, then it isn't sending out the message.
Yeah, no, I think that's an interesting point. Yeah.
Thank you.
Thank you. Peter, we'll go to your question.
Thank you very much, Lindsay, for this discussion. I've got about 5 points that I've listed. I'm a bit of a veteran of this area, so I've been thinking about it for too long, unfortunately, and I found your presentation extremely interesting. And one of the reasons it's so extremely interesting is this idea that challenging the concept of market integrity is interesting to me. Certainly the market is the object of these laws. There's no doubt about that. I agree with that completely. But the thing I think that is important is understanding the gelling of the concept of market integrity. Integrity in a lot of ways is moving away from the economist's vision that was, you referred to the efficient capital market hypothesis. What the lawyers have been doing is creating more form around the concept of market integrity for the purposes of the law, as opposed to what the economists think. So that's my first comment about that. And it's that idea about a legitimate versus illegitimate dealing, and how you, over a period of time in the development of case law, work it out. So leading on from that is the idea about where the criminal law kicks in. And certainly in Australia, it kicks in supremely for insider trading, insider dealing, and it works with enormous efficacy in that area. That area is almost exclusively regulated by the criminal law in Australia. And what's happened is we've got this suite of clever judges, clever prosecutors who are working really well on it. And what previously was a very vague body of law now bites really quite significantly. But the other way in which this all works is that I think it's interesting to compare private and public law, but I think it really exists within the framework of what we really call regulatory law, because the way that it works in Australia predominantly is that suite of penalties that lie in between public and private law, like civil penalties. That's where most of the regulation of market abuse for example, occurs. And so that's why the insider trading use of criminal law is exceptional, really. It's interesting. So, look, my thoughts generally, so this is more of a comment, is that keep working on it. It's very interesting. There's always challenges associated with using the criminal law as a body, as a regulatory mechanism in a market. And it might be of interest to you to look at some of the ways in which other public law has been applied to the markets. For example, there's been some valiant attempts to apply administrative law to the markets. I've had a little bit of a look at this, and part of the problem is, of course, the way that markets work is through special dealings between special people, and they've been able to elude the operation of administrative law. So it has some parallels, I think, with the idea of public. So those are my comments. As I say, it's a really interesting, and it's great that you're working on it. I'm really be interested to see what you do with it. They're my sort of broad comments. So sorry that there's so many of them, but it's obviously tweaked my interest. Thank you.
Thank you. So, thanks very much. There's a lot of interesting points there. It's hard to respond to, and I've noted them down. I think as a general point, I'm interested in your suggestion that lawyers are giving more form to the idea of market integrity or sort of, legitimate or illegitimate dealing. I'm not sure that I've seen that in quite the same way. So maybe in the case of say insider dealing, there's a little bit more kind of sense of that. My readings around market integrity, have suggested there's as I tried to say in the talk, there's just a tendency to kind of throw around any number of different ideas which actually rather seem not to have very much content to them, but all of which might seem in some sort of abstract sense desirable, but which are not actually kind of not articulating a sense. And it seems to me, but I'm interested in what you said, and I'd be interested in any examples you have of that, because it seems to me that it does seem to me that this is a kind of an area where we can push on and try and use it to articulate some of the kind of concerns we have about the role that markets play in society, and where what is a fair market, and where criminal law in particular might be used to regulate markets. Now, of course, as you say, there has been a huge explosion of the use of civil penalties, administrative penalties, and various other kinds of special mechanisms, deferred prosecutions, and what have you, to try and kind of in this area to try and regulate conduct. And I'm not wanting to ignore these things, although, as you know, I'm probably no doubt from your own experience, it's immensely complex and difficult to track, all the kind of developments that are going on. But it seems to me that they also, a lot of these things are existing in relation to an idea of the criminal law, that the criminal penalty is being there in some ways behind it. So the criminal is still a backstop. So we have to think about that kind of relationship too. And so, I'm trying to kind of keep it all in picture without sort of losing my sanity. And fingers crossed I'll be able to do that.
Just very short comment. The market abuse cases is the one where you get the clearest articulation of the market integrity principle. So that's my final comment. So Anton, sorry.
Thank you.
Thanks, Peter. We have a final question from Anton.
Well, thank you very much for this presentation. And just on the point about the vague articulation of what market integrity entails, I wonder if sometimes the references to the market seem to be more of a rhetorical invocation. And I think there are a couple of offences where very often you would hear references to markets, but it would be manifestly unclear at all what that would entail. So, for example, money laundering would be an instance of an offense where policymakers would often refer to the integrity of the financial system. And every once in a while, someone would ask, well, what exactly does that mean? And everyone would sort of shrug collectively and move on. And the fact of the matter is that there are other perfectly good articulations of why one might want to criminalize money laundering. So there are all sorts of various accounts of the harm of that offense that very often reach back to the predicate offense, the one that gives rise to the criminal income that has then been injected into legitimate markets. And so I think that there are some examples of offenses where there is a very clear harm that pertains specifically to the operation of markets, as in the case of insider dealing. Then there are some sort of intermediate kinds of offenses like market manipulation, where in effect you could see it as a species of fraud, could you not? And there's a clear harm to an individual victim that can be identified in a lot of cases. And then there are other offenses where often references would be made to markets, but they seem to be something of a rhetorical point. And I wonder, therefore, if there is something about the kind of state of the debate on criminalization that makes markets this appealing category to refer to. You know, if we say that something harms the operation of the markets, maybe that feels like a really good reason to criminalize an offense, criminalize conduct, and take that seriously. Yeah. So I'm not sure if that's a very, properly, fully baked question, but I suppose just thinking aloud, and I'd be interested in your comments on that.
So, I mean, it is an interesting question, and I mean, I just published a piece in the journal Legal Studies, which looks at concepts like white-collar crime, or financial crime, and market crime, and what gets put into these bags, and how useful these concepts are in terms of thinking, what the law is supposed to be doing in these areas. And so one of the arguments I make in that is, or perhaps not surprisingly, is that looking at the market is a more useful way of thinking about what might be at stake in relation in these particular areas, rather than white-collar crime or financial crime or such like. So, I mean, there's perhaps a fuller answer there. I mean, I think one of the claims at some level, I would concede the point to you that it is the idea of market integrity is perhaps invoked in slightly different ways. I mean, something like money laundering is interesting because I mean, if you look at the sort of development of money laundering offences, there's a sort of move away from the concern with the predicate offence increasingly to a focus on the, if you like, the integrity of markets. So that kind of the more recent kind of papers and documentation on money laundering are very different from the original, back in the 1970s when money laundering was first being identified as a concern. So I think historically you can look at the development of the offence and the way that the concern, the way that's framed, and you can see that there is actually a shift in the way that the purpose of money laundering is being framed, and so I think that's important. And I think it's in a sense more than just rhetorical, in that the kind of the appeals increasingly to market integrity, or the pollution of markets by as you said, I think the injection of something dark into the market, that kind of maps onto the way there are appeals to market integrity in other in other areas as well. My sense about fraud is, I mean, I'm not saying that there are not individual victims to some of these offences, but as a criminal lawyer, I would look at some of these and I'd say that actually they don't look like a kind of classical conception of fraud. So a classical conception of fraud would require that there is kind of interpersonal, that I do something which defrauds you. So I deceive you in some way and you are deceived. Now, what's really interesting about the certainly in England and Wales since the Fraud Act 2006, the fraud offence is now defined again in inchoate terms. Why is that? Because there were things like concerns with things like mortgage frauds, and with mortgage fraud, what was happening is not that any person was being deceived, because it's all gone online. So you would fill in a form on an application, and if you meet the criteria, then you maybe so you lie, and you maybe your mortgage will be approved in some way. But there's no person being deceived in a kind of direct sense. So again, it's the way that the offence is defined is moves to the attempt to deceive, so creating entering false information in the first place, not the actual outcome and the way that it's done. So, and you can see this across the whole kind of range of things around, say, identity fraud and such like. There's not necessarily a person that's being deceived. It's that because it's all mediated through the internet and kind of automated systems. So what's the concern is that if people are putting false information in, then the system is not going to be able to work properly. And so I think my argument, my sense is that there is an increasing focus on the system, and which is coming in as that's what we're trying to protect. How can the system of mortgage applications or the mortgage market, how can that work properly if people are able to enter false information and such like? It will break down. So it's, and as I say, that doesn't necessarily mean that there won't be individual victims, but that the level of the focus of protection has changed slightly from only protecting the individual victim to protecting the system as a whole. And I think that's the interesting, for me, that's the interesting shift. And I think that does cut across the different kind of areas that you mentioned.
Okay, I can see we are at time, so I'll draw the event to a close. Thank you again, Lindsay, for such a wonderful presentation, a very stimulating presentation. It's been a pleasure for our group to be able to engage with you and your work, and all the best with your book as well. And I'd like to thank everybody else for joining us tonight. Have a great evening, everyone.
Thank you all very much. Thanks for your questions, and thanks for coming out in the evening. So it's nice to meet you. Okay.
Thank you.